Would Grandma Adelson blurt out something incriminating?
How the killers knew that Dan Markel was planning to leave town the next day?
I have no idea.
You didn't relay that information to anyone?
Absolutely not.
Did you have WhatsApp on your phone at the time?
I really don't know. I have it now. I don't know if I had it 8 years ago.
Cellebrite's heroes behind the heroes. Committed to protecting our communities, our everyday heroes search constantly for all wrongdoers. But when crime hides within the digital ether, our heroes are in need of someone who can react. It's the fantastic Full Stack, along with her trusty debugging duck. Join Fantastic Full Stack as she uses her powers of SQL to solve even hardware problems. Incriminating evidence? Here's some front end. And there's the back end. We got him now. Cellebrite, a global leader in digital intelligence solutions, invites you to become one of the heroes behind the heroes. Join Cellebrite and assist law enforcement everywhere in making the world a safer place. Fighting crime is for adults only. Sidekicks sold separately. Apply now.
Let's talk about selective decoding. This is a feature that we recently put inside of Physical Analyzer. What it allows you to do is choose what is decoded application-wise. Now, something you need to be aware of. If you simply say, please decode WhatsApp and maybe Snapchat, you will also have underlying artifacts that may pertain to WhatsApp and Snapchat that are also parsed. So don't be alarmed if you get some photos and maybe contacts and calls that were made inside of these applications. We are trying to make a list that makes it crystal clear to you on what is included when you select these buttons. So stay tuned for that. And as always, I want to hear your input. If you have a request on what is included in selective decoding, please send it my way. In order to leverage this, I'm going to choose File and Open Case. The case wizard is going to open. Select Add and then Load Extraction. So I'm going to load a UFED extraction. I'm going to navigate out to my desktop and into some images that I have. And I'm going to choose this UFDX file. From here, you want to select Next. Now comes the important part, and you will see this new button that appears, and it tells you to learn more. You can always select on it, and it tells you what selective decoding is, and it allows you to choose apps you wish to decode to speed up the processing time. So I'm going to say yes, I want to include that, and examine data. At this point, Physical Analyzer is going through and scanning all the applications that are available on that device. This may take a few seconds or a few minutes, so just be patient. A list will appear when the scanning is complete. Now you have several options on what you can do. You could say, you know what, I only care about social networking applications. I want to go into that category and I want to check boxes for those items. Or I want to search for it. I know that WhatsApp is important to me. So I'm going to search for WhatsApp and I'm going to choose WhatsApp Messenger. Now notice when I check WhatsApp Messenger under chat applications, it also checked the box under social networking. Once you're happy with what you have included, select Continue. At this point, processing will go through, as always, in Physical Analyzer. However, it's going to be faster because you have taken control on what you want to process. This is a fast way for you to triage your case or get a quick glimpse on what the user was using for applications of interest. Hi everyone, Heather Mahalik here with another Tip Tuesday. I want to discuss with you a new feature built into Cloud within Physical Analyzer. So I'm going to go to Cloud Extraction Private Cloud Data, and I'm going to enter the first and last name, Hank Rules of the person I'm examining, my examiner names, original extracted value, and any other options of choice. So you can choose your path and whatever you want to save it as, and then press Next. Now I want to search for WhatsApp because I want to show you this new WhatsApp web chat feature that we have. And here you're going to see that it's telling us you must have access to the user's mobile device. Obviously, it has to be unlocked because you're going to have to scan the QR code. I select Save, and I'm going to select Next. And you'll see when it's trying to validate, it is going to tell you that you need to scan a code. So QR scan required. Enter your name, giving it authority and saying you have legal rights to do this and proper jurisdiction, and say I approve. So then I go up and I scan this code. So now I scan the device, and you can see it says valid, and we select Next. You can choose a date time period on what you legally have authority to be examining. So I'm going to choose January 1st through now and say use for all data sources. And as you scan down, it's going to show you what it can get. So I'm going to say apply and next, and then start extraction. At this point, Physical Analyzer is going to extract the private cloud data from this WhatsApp web based upon the QR code that you scanned and provide you access to unique artifacts that you may not otherwise have access to.
Did you communicate with anyone on WhatsApp or similar technology to relay any information about the murder of your husband?
Absolutely not.
Do you know if your brother Charlie had WhatsApp at the time?
I have no idea.
Did you communicate with him through WhatsApp?
If I had WhatsApp on my phone, then maybe I did. I know I had friends who lived around the world. At that time, WhatsApp was more of a technology used to talk to people internationally. So I know the friend I was talking to was in England. If I had WhatsApp, I would have used it to call him.
Did you know that WhatsApp, the communications are encrypted? They cannot be retrieved by law enforcement? Were you aware of that?
I think they can be retrieved by law enforcement, but it's one of the end-to-end encryption services.
All right, and so you can't tell the jury whether you communicated through WhatsApp at all on the day of the murder?
I don't remember if I had it 8 years ago. I have it now, so we could look and figure out if I had it then, but I don't know.
All right, did you ever communicate with Catherine Magbanua at any time through WhatsApp?
I never communicated with her at all.
Here with another Tip Tuesday. For this week, what I wanted to focus on was looking at chat messages. As we can see here in my left pane, I have several chat messages of interest. One thing that I find overwhelming is when you're trying to dig through 8,494 messages, it can be difficult to view what you want to see. When you find a message of interest, like I have here highlighted in blue, you can simply double click and switch to a conversation view. The conversation view makes it a lot easier for you to visualize the message and the going back and forth. Something else that may be interesting to you is clicking on filters and just selecting everything with attachments or without. So in this investigation, which I'm showing you here, this is my own phone, I am pretending that I wanted to find all chat messages with attachments. An additional thing you can do is this pane on the right-hand side can be hidden. I prefer to have it in my view because I like to verify all my sources. But if you wanted that right pane to go away, simply select Actions, right pane, and it will disappear, giving you a fuller view of your chat messages. To bring it back, simply select Actions and right pane, and all your messages reappear. Thanks and have a great day. Hi everyone, Heather Mahalik here with another Tip Tuesday. This week I want to share with you something that we added regarding iOS 16. So when we look at iOS 16, most of you are aware that new features were added. One of them is the ability to unsend and edit messages within a set period of time after the message is sent. If you want to take a look at what this looks like, we can see here that I am in Messages in Physical Analyzer. And when you find a conversation of interest and things possibly just aren't making sense, take a closer look at the message. So if we look at this and you look at the date timestamps, you will see specific timestamps on these two conversations going back and forth. And then you also start to see some of the testing that Edo had conducted here. So we can see before edit, after edit 1, and we see this trash can. Before edit, after edit 2, and we see the trash can. So as we're going through and we're looking at these edits, what you're going to see is the edited ones actually have a trash can next to them, showing that they are not the original message. The source file for this is going to be the SMS database. So when you're looking at these messages, take a look at, for example, this one here. Before edit, after edit 1, it has a timestamp of 2:09:17. But if you look up, you see that there are other messages that exist. So the edit may be not the very first message, but the messages that things are changed to. If this is confusing to you, what I recommend you do is read the blog that Ian Whiffen wrote. He is doubleblack.com. There's a blog on iOS 16 messages. He released this in June of 2022, and it breaks down everything you need to look at in the database to verify the edited messages, the dates that they were edited or unsent, and how to verify.
Hello and welcome to our next episode of Modernizing Investigations. Why digital intelligence is important to the prosecutor and why that importance is increasing. I'm Matt Geckel. I'm a solutions engineer with Cellebrite. Prior to joining Cellebrite, I spent about 18 years in law enforcement, worked all manner of cases, and ended in the digital forensics lab where I worked for about 10 years. With me today is our special guest, Brian Kramer, and I'm going to let him introduce himself. Brian.
Well, good morning, Matt. I'm Brian Kramer. I'm the state attorney for the 8th Judicial Circuit of Florida, which is in north central Florida, covering 6 counties that include Alachua, Union, Baker, Bradford, Levy, and Gilchrist County. Approximately 300,000 people that I represent, and I prosecute cases on behalf of the state of Florida. I've been a prosecutor for about 23 years and admitted to the bar for about 27 years. And in my role as prosecutor, I'm the chief law enforcement officer for the 8th Judicial Circuit of the state of Florida. And we prosecute in my office approximately 20,000 criminal cases per year.
Wow. All right, so we moved into this phase, right? The arrest has been done. Prosecution or prosecutors, you guys are now the lead on the case effectively, right? The case is now yours, it's in your court, and like you were explaining, we have to go from probable cause, which is the standard for arrest, to somehow get to proof beyond a reasonable doubt. Oftentimes, this means that law enforcement's job is not done as well, right? There's could very well still be investigations that need to be done. And when it comes to digital intelligence or digital evidence, there's still could be a lot to look into. Is that correct?
Yeah, that's very fair. So in major cases especially, often an arrest can be very, very early in the process, especially if it's a violent crime where the suspect is known and available to be arrested. There's a large impetus on law enforcement to make a very fast arrest. So that probable cause phase really would be shortened by the circumstances, and that isn't the end for law enforcement. They're still going to be working and developing probable cause and developing the things that law enforcement needs to do, but that's now going to be occurring essentially simultaneously with the prosecutorial phase, and they're going to be running, you know, sort of together at the same time, and we're working hand in hand with law enforcement to do the things that we would do, you know, to develop probable cause and to flesh out all the things that we know we need to do, but at the same time developing on the prosecutorial side that. Now, if the suspect isn't available, you know, or the person isn't arrested, you know, those time frames can be elongated, right? But yeah, it is essentially handed over to the prosecution once the arrest is made, but law enforcement is by no means done. Not in our jurisdiction and not in most.
Okay. And it brings to mind a case that you and I worked together, and it was a while ago. It was very early for us in the days of digital forensics, 2012. To kind of sum it up very briefly, it was a case where a student went missing, and he was reported missing, and we, from the law enforcement perspective, were able to figure out very quickly that he was likely dead. You know, but obviously there was kind of absent that person or that body. There was still, that question was still out there. But just based on the circumstances of that case, we did move quickly to an arrest for charges that we had that weren't homicide. And you, as the prosecutor, became involved very quickly in that as well. The reason that it sticks out to me is because, aside from the other evidence that we had in this case, there was a large digital intelligence component to this case between cell phones and everything else. Can you talk a little bit about that from your perspective?
Right. When the case happens initially, we have a missing person, is really what it comes down to. And we, as law enforcement, quickly know, because this person's digital footprint has essentially disappeared, that their pattern of life has ended. So we know from a law enforcement perspective fairly quickly that this person is deceased. But we don't have a body, right? And we have a suspect who's telling us that the person isn't deceased. So in that case, the digital forensic evidence that was available, not only of what had happened during the crime itself, but sort of that absent footprint became incredibly important, because we were looking at that point, a victimless prosecution. There was going to be a prosecution without a body. You and I went to the grand jury and went there without the remains of the individual having been located at that point. Right. And that's why the digital forensic evidence was incredibly important for both aspects of the case, right, in that case.
And so, speaking specifically to the victim in this case, the digital evidence is what you're saying is that we were able to prove, based on that evidence and then the lack of activity, right, at a defined point in time, on everything that he had, which not only included his cell phone, but him getting on the Wi-Fi on campus or using his student card around campus, things that he would normally do, that we knew he would normally do based on talking to friends and family. All of it stopped.
Right. His entire pattern of life ended, and we were able to, or I should say you, were able to document, first of all, what was his pattern of life, and it was evident all across his digital forensic footprint. It was things as simple as how frequently did he use his telephone to call his mother and his father and his brother and his girlfriend. We were able to see that pattern easily, right? Then it was things like, where was he on the campus when he would access the campus's Wi-Fi network? How frequently did he access the campus's Wi-Fi network, right? When did his text messaging stop? And we were able to document that entire pattern of life in very finite detail, and then show that cessation to be exactly commensurate with his encounter with the defendant. That was incredibly powerful evidence that, number one, he was dead, and number two, that the defendant was the person he was with when that cessation of life stopped. Right, and that was critical evidence in that particular case to show that he wasn't alive anymore.
And it's a very good point, right? Talking about how the digital evidence, and we didn't have the actual cell phone. We used supporting records and other pieces of digital intelligence to show that. And you mentioned the defendant, and we mentioned, showing additionally building his pattern of life. And his was very interesting because, again, it was kind of early in the forensic days for us as an agency doing mobile forensics. Again, it's 2012. I'd been doing it for I think a year, maybe two at that point. But it was interesting that his cell phone was really searched post-arrest, and so there was that need to go through and see what, if anything, was on that device that might prove whether or not he was, culpable of the murder, what activities he had taken or not taken, and really to build, again, his pattern of life, right? To build his activity leading up to the and post homicide.
One of the things that you taught me during that case was the difference between the two phones that the individuals had. The defendant had what essentially was a smartphone at that time, and the victim had essentially a flip phone at that point.
Yeah.
And one of the major differences that we examined that you showed me was the range to tower. Like the defendant's phone, we could get range to tower data, but with the victim's phone, we couldn't get range to tower data. It was in a really early phase forensically for that type of information. But yes, we were never able to recover the victim's phone.
Right.
We searched and searched and searched for it, but we never were able to recover it. But what we were able to do was to get the cell tower data, where the phone had touched, the records that associated with that, and also to, in a very, what was then primitive way, associate those two records together. So they had two carriers, but we were able to show those phones being together, hitting the same towers, even though they were different carriers. Some of those towers were simultaneous to each other, some of them were separate.
Right.
But to able to show that pattern of movement together, but also then to examine the defendant's phone, which showed not just his pattern of life, which we were able to see very, very clearly, but also to compare his statement of what had happened in the time frame of the crime with what his digital device was telling us about what had happened in the time frame of the crime. Yeah. And ultimately, even in those days, we were able to very quickly confront the defendant with facts that, through digital forensic evidence, that he could not explain.
So this was an interesting case for us because, not only everything you've talked about, where we're using cell tower data to put the defendant and the victim together, and then using the post-homicide data from the defendant to show his route that he took home, right? Using that stuff, but also the fact that he used what he thought were counter-forensic measures to throw us off the scent. I remember vividly one of his statements was that his phone had died. And for context, at some point the defendant's cell phone records just kind of stopped with the carrier, right? They just cut out. He told the investigator that his phone had died, and we were actually able to locate a log that showed that not only was that not the case, his phone was still alive, still had a charge, was still being used, but had also been put in airplane mode. So he was clearly trying to take steps to hide his next activity, which we later learned over the course of the investigation was him actively going and hiding the body or disposing of the body.
I remember specifically you explaining to the jury that every time he touched the home button, at that point in time iPhones had a home button, that it would make a notation in the log of the time and the fact that it had been touched. And of course, that was important not only to show that the phone was on, but also to show that his story that he was sleeping during that time period was false, because his story was, I'm asleep in my residence at the time that we know that he's repeatedly touching and that his phone had died and he went to sleep, right? But we know that the phone is on and he's repeatedly touching the home button. And then we get to sort of the most important thing that you discovered during the case, was that when you looked through the iPhone and you were able to determine that he had used his flashlight for a period of 43 minutes during the time frame that he said he was asleep and that he wasn't doing anything. And of course, we successfully argued during the trial that 43 minutes is just about long enough time to create a shallow grave to dump a body into.
Yep.
Right.
Yeah, it was. It was an interesting find for me. It wasn't really something. The blogs were very sparse back then, right? For me, it was one of those aha moments, and it was just matching up the log of the battery being drained during this time period that coincided perfectly with the log showing, his flashlight usage for the day, which showed all of his app usage for the day. So it was really interesting, and ultimately, he used his phone and his laptop to also prepare for this homicide. We found, aside from the data on the phone, I think on the laptop, and I didn't do the laptop, so I wasn't there for that, but I believe we found records of mapping and searches that matched the area where he ultimately hid the victim. So it was really interesting from a digital intelligence perspective how much came into play. And one of the things for me that I really think kind of sums up this is that with all of that digital evidence that we had, it was really used as a tipping point, right, for the case, because there were other things, and it's always been interesting to me how little I know about the overall part of a prosecution, because I live in my digital intelligence bubble. But we had DNA and I mean, everything from soil analysis. There was so much other stuff that went into this case, but really having that digital evidence to show patterns of life, activity, lack of activity, and tie that into, hey, aside from everything else that we have that says this guy did it, we also have this stuff that supports everything we're saying.
Right, and this is one of the first cases where we got into a situation where we're using digital forensic evidence to make essentially micro-verifications of other evidence in the case. And here, for instance, one of them was we had digital forensic evidence that he had done a search of a particular area in a particular county in where the body was located, right? Well, we then took soil samples from the bottom of the car and from the area where the body was located, and those soil samples match. So we then have digital forensic evidence verifying, or giving it what we would call a micro-verification of another piece of evidence, and it ties together in a web that becomes something the defendant just cannot get out of. Right? You could get out of any one of these things, right? But you can't get out of all of them. And then when you start tying together where you put him when he turned off the iPhone, or when he put it into airplane mode, where did you put him when he put the iPhone in airplane mode? Where did you put him when the iPhone came out of airplane mode? Right? And we show that is on the path to the same place where the soil analysis matches with where it's the same place that he did a search of a map of that area. These things all start to map together and verify each other in a way that the defendant cannot get around.
Right. And as a matter of fact, you say that, but when I was able to go back and actually watch you cross-examine the defendant on the stand, hearing him validate my work that I did and say, yes, no, Detective Gecko was correct, and this is the route that I took, and these records are accurate. Hearing that was, to me, very significant, right? Because you're exactly right. He realized at that point, hey, no, these guys actually know what they're talking about. These guys know what they did. And I think that really underscores the importance of having this data available to change a defendant from, no, I was doing X, Y, Z, to, okay, well, in fact, let me change my story to try to fit law enforcement's narrative. Really underscores that.
Remember, the defendant always goes last in a criminal trial, so he has the opportunity to hear everything and then specifically tailor his story to the evidence. And remember, admit what you can't deny, and deny what you can't admit. right? This is the fundamental principle of being a criminal. And what you did in this case is you really made it where he had to admit everything he could not deny.
Yeah.
Right, and that's what causes a criminal conviction in a case like that.
Yeah, it's an interesting thing, I think, here that we have kind of unintentionally waded from the investigative phase for the prosecution into the prosecution phase, or the trial phase. And so I think we should just transition straight into it, right?
Sure.
So we've talked about, the importance of prosecution as it relates to the initial investigation, right, and gathering this digital evidence,
right,
and this digital intelligence, right, which we use to encompass everything that's digital, from CCTVs to body cams to phones to computers, gathering that in a manner that is court proper, right, court admissible, to transitioning to a phase where you now have the case and have the task of taking it from, hey, we have enough information to believe that this person is the one that committed the crime, and here's the reason that we have that, to take it from that to be able to tell a jury, no, there's nobody else that could have committed this crime, right? Beyond what we say, the reasonable doubt, right? Moving from there, right, in those phases of the investigation, now we're in the prosecution phase, which is really the trial phase. So can you, from a digital intelligence perspective, can we talk about that and you telling the story to the jury and everything?
I like to think of this transition this way. As a prosecutor, I'm looking at the digital forensic evidence along with all the other evidence and the testimony that's available in the case, and I'm asking myself, can I prove this case beyond a reasonable doubt? Do I believe I can prove this case beyond a reasonable doubt? The next phase begins when I've answered that question, yes, and now I'm asking the question, how am I going to convey all this information to a jury in a way that they are going to be able to understand it, digest it, believe it, and reach the same conclusion that I have reached about the evidence, right? And that's where the prosecution phase really begins. The trial phase begins long before the trial. It begins when you're contemplating, how are we going to present this? And this is something that has changed remarkably over time, right? We've started off with 3-ring binders, with spreadsheets, that may be 1,000 pages of a tower dump, that are incredibly difficult and esoteric, that no jury would possibly ever understand, and basically having to promise juries, we will tie all this together for you at the end in the closing argument, right? And that's what we have done, is we have looked at this evidence and we have said, we are going to present to you silos of evidence, and here is Instagram, here is text messaging, here is Facebook, here is phone data, here is and we're going to tie all that together for you at the end to reach an inextricable conclusion, right? That's been the model for a long period of time, and digital forensic evidence has become sort of the gold standard of those silos, right? You have another silo of witness testimony, but juries regard witness testimony as perhaps the least reliable of all of the silos of evidence that we can look at. And we have other evidence, we have physical evidence, but that can be tampered with, and it can be changed. And really where we've moved to, as I was talking about in the beginning, is from this idea of, can we trust digital forensic evidence when it comes into a criminal case, to now the point of, can we do anything without it, right? Can we proceed to a case if we don't have those silos of digital forensic evidence? And that's essentially where we are and have been for the last 10 years, is trying to present these individual silos of evidence to the jury and then tie it all together for them at the end, hopefully in a way that they can understand. And that's why it's been having technicians like yourself, when you were working as a digital forensic technician, that can come to the courtroom and can explain to the jury in a way that they can understand. That's not, computer talk that they can't figure out. And it's been extremely challenging. It can be extremely challenging and extremely time consuming to do that.
Yeah.
Right.
Yeah. No, I agree, because I've been a part of that challenge, right? And I've ask juries to use their imagination, while I try to explain concepts to them, because oftentimes it's just me on the stand, and I may have a visual aid, right? But I may need to get them to the point where they can understand the visual aid. And so I think there's a definite need to make sure that the data that we're presenting to them as lay people, right? Because these are the reasonable, prudent people that we are asking. It's law enforcement is jaded, prosecution is jaded. We've seen too much, we know too much. We know things about the case that maybe aren't even admissible that would slam dunk it, right? Something happened that for some reason they're not gonna ever hear that data. And so these are the people that we have to help to understand what actually happened. And it is a challenge. And then aside from being able to explain it, the ability to present it, like you kind of mentioned, right, is in a manner that resonates with a jury, right? Here's a PowerPoint of spreadsheet screen grabs, right? And I'm going to read you text messages,
Right.
And I have watched them struggle to stay awake. I have watched them space out, right? Versus something like, hey, here is some chat bubbles, right? Here's how it looks on your phone.
Right. And one of the things, Matt, is jurors' expectations are driven by the media, right? And the media is generally on the cutting edge of what technology is available because they're the entity that's presenting it to the public. And jurors have an expectation that what they're going to see in a courtroom is essentially what they're seeing in their lives and what they're seeing in the media. And the problem that we always face is that the courts are always behind the rest of society in essentially everything.
Right.
So the courts are also behind society in technology, that we don't have, or at least until recently, we haven't had good methodologies to combine things in a way or to display them in a way that would be allowable with the court, but also meeting jurors' expectations of what they expect to see in a courtroom, right? Their expectations, and we spend a lot of time trying to dampen their expectations and explain to them why something is going to look so clunky and not what they're used to seeing.
Why it takes more than 30 minutes to get a DNA result back.
Right, but also
not CSI.
Why is it that instead of showing them here's the phone, take a look at it and see what this person did, why do we have to break it into 1,000 parts and pieces and put it into spreadsheets and maps and the various things that we have to use to explain this to them, and then make it from something that they know and they understand and that they use every day to something that's very esoteric and very difficult to comprehend and requires experts and training just to understand what's happening, right? That's really been the challenge of prosecution, is how do we meet jurors' expectations as it regards digital forensic evidence? And that's really the future of prosecution, is always how do we meet jurors' expectations to secure criminal convictions? Because we can't simply ask jurors to not expect the evidence that is out there and is available, that they know is out there and is available, right?
Right.
They have an expectation, and when you fail to meet it, explaining to them why you failed to meet it, it usually results in a not guilty.
Right.
Right. And that's, as prosecutors, that's what we're hoping to avoid.
Right. So Brian, what does the future of prosecution look like for you?
Right. So the future for prosecution, as it relates to digital forensic evidence, really surrounds the idea of meeting jurors' expectations. And jurors expect to see things in the courtroom like they would see them in their lives. So what we're hoping for and looking for are products that are going to allow us to show jurors how things work in real time, in real life, but in a format that's acceptable to the courtroom, that involves documentation, provability, indexing, being able to repeat it, being able to prove its authenticity, right? And that's why we're looking to products like Pathfinder that are going to be able to integrate all of the things in people's digital forensic life in a manner that they will understand and they would expect to see it, and have that presented in a courtroom environment in a manner in which they understand it and expect to see it. And that's where we need to be going, and that's where we're going with Pathfinder itself, is to be able to make all these ties together, to take all of those silos that we have forever had to present as individuals and say, trust me, we're going to put this together for you at the end, and stop doing that and say, we're going to put this together for you right now.
Yeah.
We're going to show it to you right now. We're going to be able to show it to you the way it happened, as it happened. We're going to be able to show you the connections between people in the time frames in which they happened. The digital forensic connections that we all know are multifaceted, right? People don't just use text messaging. They shift from text messaging to email, to Facebook, to Messenger, to Snapchat, and they're doing it in real time, right? And we've never been able to present that to jurors in the way that it happens on a phone. And Pathfinder is going to give us that ability. We're going to be able to show a jury, hey, this is how it happened. This is what it looked like when it was happening. Will it be absolutely perfect in the way that it's presented? Is it going to be a film of the person using their phone? No, but is it something that they can see it all in one shot, the way that it happened? Yes, and that's really what the future is. It's getting away from this boring, long, technical presentation of individual silos and moving to an integrated presentation of what it looked like when it really happened.
Very nice. And you basically took the words out of my mouth, and when I was listening to you, is effectively having a solution that can help eliminate some of those silos for you, right? You know, thinking back to my testimony where it's, okay, we're going to talk about the phone records. All right, now we're done with that. Now we're going to talk about the phone extraction. Okay, now we're done with that. Now let's talk about Facebook, and putting all these individual things and watching jurors furiously take notes and try to figure out, okay, how is this all interrelated, versus being able to show, hey, here's, again, that pattern of life, right? Here's all of the digital data about this particular individual or people put together in a way that's easy for you to understand. And it's interesting you bring it up with the silo aspect, because that's another, within law enforcement, an issue that we face often is investigative silos, right? So where one unit or a particular person may be looking into people that another unit or person is looking into, and no one has any idea that they're both looking at the same person for two different crimes. And that's another thing we're trying to eliminate. So it's really interesting to me to hear that silo concept is so, you know, it's across the board, even to the point of prosecution, where we're trying to present this data and this evidence, and it's largely siloed. And a lot of it has to be, because you have different witnesses that talk about stuff. But when it gets into digital evidence or digital intelligence, a lot of times it's the same person, right? It's a lot of agencies use that one guy, right? He's the computer guy, maybe, so he does everything that has anything to do with computers. So very interesting points, and thank you so much for it. So what are you doing in your office to keep your prosecutors, aside from looking into additional solutions? Are you looking at is there a training aspect to it as well, and other things that you're doing to keep your prosecutors more modernized with the investigations that they're a part of?
It's definitely a training aspect. It's a working with law enforcement, utilizing the tools that are available, but also making sure that our prosecutors understand what is the latest technology that's available, how is the technology changing. We need to understand, just like we talked about in 2012, that defendants will take counteractivity, that those things exist, and that law enforcement and law enforcement partners are ahead of them, and that they're able to defeat these defendant counteractivities before they ever even happen, and that how do we know what to do in that situation, right? How do we know where to look, right? And we rely upon law enforcement to tell us, here's what you need to be doing, here's what you need to be asking for, right? Here's what you need to do in the courtroom to make that happen. Yeah. Right. That's really what we do to keep our people, on the cutting edge of technology.
Very nice. And I've done personally a couple of sessions with your attorneys with regards to kind of this continuing education aspect from a digital intelligence perspective. Do you think it's important from a prosecutorial perspective that that they are making sure to look in-house, or you know, especially with budgets the way that they tend to be in government, you know, you may not have the budget to bring in some outside expert that costs tens of thousands of dollars for you know, an hour of their time or whatever. So you think it's important for prosecutors to look inside, right, their agencies that they support, for those experts to be able to help guide them on that journey?
I do, and you know, I'll give you an example of like how this is incredibly important. You know, for instance, when you instruct our prosecutors 2 weeks before, you know, that it happens that the next version of iOS is going to allow a user to delete a message, right? If you're prosecuting a stalking case, this is incredibly important to know. Right? You need to know that when a victim comes in and tells you, I swear to you there was a message there, and then it went away, and this is the difference between thinking a victim is lying and knowing that a victim is telling the truth, and being able to go to your digital forensics technicians and say, I need you to be able to tell me if this happened. Right? That's incredibly important. And it is a challenge for a prosecutor's office to be able to internalize all of the necessity of being able to keep up with these things, to be able to have the resources. It's hard from a budgetary standpoint to be able to do that. And that's why we rely mostly on our law enforcement partners to do that. There are times when we want to be able to sort of handle it ourselves, but they're mostly, in my situation, in my state, they're mostly budgetarily limited. An example would be, we might be able to afford the technology to be able to take an extraction from a phone when a person comes into our office, right? But what we won't have the budgetary ability to do would be to employ a digital forensics technician who could then go through that phone and do the things that are necessary to help that case along, right? That's really, again, goes back to our partnership with law enforcement, and how do those things continue on together, these investigative techniques, how they work hand in hand with each other, right? We may download someone's phone, but ultimately I'm still calling you to say, Matt, I don't know what's going on here. You're going to need to look at this thing.
And of course, right? I mean, the importance of not only kind of come and sit down and you know, mostly at this point natively understand what it is you're asking me to do and presenting to me, but being able to turn around and back that up, right? If it does go to trial, right? Be able to sit down in court and explain to the judge and the defense and the jury why I'm qualified to be sitting in front of them and explaining what my findings are. And so yeah, it's interesting. You brought up the iOS thing. It's still this ever evolving market, and you know, some of them are features that I guess are neat, right? The ability to edit a text message, which I don't know. I mean, I've typoed before and I just correct myself as opposed to wanting to go back and edit it, or to delete a message, which I'm not sure of any legitimate use cases there, unless you just really speak your mind and then change your mind. But it's just interesting that these changes are happening, and it is something that we've actually already started researching. Some of our researchers are looking into it. I think one of them has already blogged about it. So it's definitely, you know, something that everyone's going to want to keep an eye on. But it underscores again that need to stay current, stay modern, and keep up as best they can with the technology. Because I can tell you now, the criminals are, right? They're becoming more savvy. They understand technology more than we probably give them credit for sometimes, to the point where, you know, aside from the fact, like we talked about, where they might actively be trying to cover their tracks using their phone, or try to cover what they're doing on their phone, they can essentially commit a bulk of their crimes, depending on what it is. Let's say it's a financial crime or something like that, right on the phone. These are computers now. So it's really important from everywhere that we keep up with it. And like you said, that prosecution and law enforcement have everyone, that's all law enforcement, prosecution and police, whoever, right, have that partnership, that trusted ability to rely on one another to get the job done. We're all working towards one goal. We want to make sure the guilty person goes to jail, right? Which includes, you know, looking at this digital evidence for exculpatory evidence or whatever it is. But it's very important that we work together.
Right, and it's important as prosecutors, because we can't spend our time trying to understand what's happening what's the latest thing in the digital world, we're relying upon industry to translate that to law enforcement, to educate the prosecutors, in order to stay ahead of defendants who might use technology for an unlawful purpose. And that's a hand-in-hand partnership between the three of us that if we don't have it, we will have a lot more crime and a lot more people getting hurt.
Yeah, agreed. And that's something that we at Cellebrite, is part of the reason I joined Cellebrite, something that we strive to do is to be that trusted advisor and that trusted partner to law enforcement and prosecution. Anybody who's involved in the law enforcement world, right, the law enforcement arena, to be that trusted advisor to, hey, if you need help with something, if you have questions, come to us, right? Or, you know, hey, here's our latest and greatest, and we're employing these geniuses to figure out, you know, what's happening on these phones, what does it mean, and how can we translate, right, to the point where law enforcement can understand it, that can make sure that the prosecution and the jury understands it. So it's really interesting. But yeah, we've definitely been trying to have that, make that a reality here at Cellebrite. So yeah, so I mean, I think we kind of covered everything there. We talked about the three phases, the three main phases, which and again, we inadvertently moved from one phase to another, and it just showed the fluidity of it, right? It's not three distinct separate phases every time. It's really this ongoing activity. But Brian, I want to thank you a lot for coming and sitting down with us today and giving us some of your time. I know that you're very busy.
No, it's been wonderful to be here, and it's wonderful to have an industry partner who cares so much about law enforcement and getting the right people, in the right places to do the right thing.
Yeah. You know, thank you everybody for joining our episode here on Modernizing Investigations. We hope that you got a lot out of it. If you do have any questions, please feel free to reach out to us. You can find our contact information on the website. Feel free to email me directly, and otherwise we will see you on the next one.